In this video, we're going to talk about the pros and cons of filing for probate yourself or going through as a pro per, so stay tuned. Hey everyone, Josh V. Welcome back to another episode. In this video, we're talking about DIY probate, doing it yourself, and why you should be warned and stay away from doing so. In California, there are two main ways that you can file for probate. Number one, you can file as a pro per, meaning you seek the assistance of a legal document service, which there are several. Or number two, you could choose to handle all of the documents and fill them out yourself and represent yourself in court. The other option is to seek the help of a professional licensed attorney. So we are going to talk about the pros and cons of doing it yourself or seeking the help of a legal document service. Let me just say that the pros of doing it yourself or having a legal document services, it's that they're cheap, right? They're gonna charge you anywhere from $3,000 to $4,000. And quite honestly, a lot of people that choose to petition the court for probate choose to enlist the help of a service like that or do it themselves because it financially makes sense, right? They're gonna charge you $3,000 to $4,000. But on the downside and the con side of it is that most likely you are going to end up getting continued by the time that you show up to your hearing. So you're not actually having an attorney that's reviewing the paperwork and that's doing it honestly correct a lot of the time. So there's a process, from the first time that you file to when you have your hearing. There's a publication that goes out. A couple of weeks before the hearing, there are probate notes that the court issues. And usually a lot of the times those probate notes get missed by legal document services. I'm not saying they get missed 100% of the time, but by the time that you show up and get in front of the judge will say, hey, I'm missing documentation and I can't appoint you today as the personal representative. Please come back 60 to 90 days from now. Let's look at the calendar. Okay, great, come back then. So what that does is that essentially stalls your appointment date. And so now you've gotten another hearing, 2 to 3 months down the line. The other side of that is, hiring an attorney. The pros is that you have somebody that is experienced, that does this every day, that is a licensed attorney that is going to make sure that the forms are filled out correctly and gets you appointed on your first hearing date. And of course the cons is that yes, they are more expensive. They have a fee, which is a statutory fee based on the value of the estate. While a legal doc service may charge you $3,000 to $4,000, an attorney might charge you 3 or 4 times that. Is it more important for you to have your time, or is it more important for you to save money? And that's really what it boils down to. Some people choose to, pay the $3,000 to $4,000 because it makes more financial sense. And some people wish to kind of be removed a little bit, not have to show up to court, have that peace of mind that someone else is taking care of it for them. I just wanted to make this video to warn you of the pros and cons of doing it yourself versus enlisting the help of a probate attorney that's actually going to show up to court, to your hearing, and make sure that everything is taken care of. So hope this video helps. As always, if you have any questions, call, text, email. You'll be glad you did.